The next speaker that we have is a friend of mine. He's also my attorney, family law attorney, so don't beat him up too bad. He was kind enough to come down here and speak a little bit about what he thinks about shared parenting and what he witnesses in the family court system. Justin Jackson.
I echo many of the remarks that I've heard today, and so I'm going to try and keep my remarks brief. I just wanted to share some thoughts on the court system and what I see in terms of the law and the way it's played out in my experience as a family lawyer. So again, my name is Justin Jackson. I'm the managing member of the Jackson Law Firm. My office is in Cedar Park, and frankly, I've witnessed a whole lot of injustice that I've experienced being Stewart's lawyer, and I've handled so many other cases where I've seen some of the same stories that I heard Sean, who came up here earlier, I heard his story. It's a very common story that he shared, and it's an unpopular topic for lawyers. As a matter of fact, I spoke to Stewart a little earlier, and I think I'm the only lawyer here to speak in support of this bill. And the reason is, the reason is, family law is a big business. There's a lot of money involved in it, and it might sound a little odd that my hope is that this bill passes and that my business shrinks, but for the sake of all the families across the state, I think that's what's in the best interest of children. It shouldn't be about the money, it should be about the best interest of the children. And there's a part in the Family Code that talks about the public policy of the state. The intention of the Family Code is very specifically to serve the best interests of the children. And in my experience, that's all lip service. It is not to serve the best interests of the children. It is to essentially promote a concept of unequal parenting. And unequal parenting is a very old-fashioned and outdated notion. I looked up some statistics, and there are less than 29% of households in this country that have a stay-at-home parent. And so what that really means is we're in a day and age now where in the past we weren't, where we have working parents and we have parents who are equally involved in raising their children. And so the law needs to change and catch up to the times and reflect that that's where we are now. We're in a situation where fathers and mothers equally rear their children. And now granted, there are situations where that is not the case. But this law, if you read it very carefully, it provides an exception for situations where the judge finds that equal parenting time is not appropriate. But what we need today is a reset button. There's been, for too many years, this notion that one parent is superior to the other parent. And the reset button is House Bill 453. Now, one of the reasons that the family law has become such a big business is the two big things that are at stake. Now, the first one is very obvious, and in fact, it is what is directly addressed by this bill. One of the things that's directly addressed by this bill is equal parenting time, but that's only one aspect of what I think future legislation needs to address. But I think indirectly, House Bill 453 does address it. And so House Bill 453, while it specifically addresses equal visitation time, the other reason that family law is such a big business is when a judge orders one parent to have more time than the other parent, what almost happens as a knee-jerk reaction is there's an order of child support. And now, sometimes, again, there are times when child support's appropriate. There are parents with unequal means, and so child support is appropriate in some situations, but the system today approaches it in a very knee-jerk fashion, where one parent has to emerge with more time than the other parent. And as a result, one parent receives child support and the other doesn't. So when the stakes are that high, where not only are you fighting for equal visitation time with your children, but you're also fighting for money as well, that's why family law has become such a very big business. And I've seen hundreds and hundreds of custody cases where retirement accounts are liquidated, savings accounts are liquidated. And unfortunately, the only beneficiaries of that are the attorneys. They're the only ones who benefit from that type of a system. The only opposition that I've seen to this bill has been the family lawyers and the family law lobby. And I think that's very unfortunate. And I think it also speaks a great deal to what the motivations are in terms of the opposition. So what I'm hoping is that we'll see that this law implemented it, but if we don't see this law implemented, that the fight will continue, that parents will continue to show up. I think that the numbers here today are not reflective of the true support of this bill. If I had just my clients who have voiced support in this bill, it would greatly outnumber just the people who are here today. But again, for personal reasons, whether it be work-related or otherwise, they're unable to be here. But the support for this bill is great, and I think it's unfortunate that we're even having to ask the question, why House Bill 453? The fundamental notion of this bill is equality. And equality has always engendered positive notions in our society. But when it comes to equal parenting time, it's taboo to some people. And I think that's very unfortunate. That should always be our starting point. Children should not be treated as pawns in a courtroom. They should not be something that there's a monetary attachment associated with them. It should be that it's proven that there shouldn't be equal time with children. That's where the court battle should be waged, if there is a court battle. The court battle should not be waged over whether one parent gets more time with one parent than the other. And for those of you who are unfamiliar with the current state of the law, the Family Code provides that there's a rebuttable presumption that a standard possession order is in the best interest of the children. So the moment any parent, male or female, walks into the courtroom, they're having to fight against a notion that one of them will walk out a winner and one will walk out a loser. And that's where the battles are waged. They're battled there, and then consequently, as I mentioned earlier, they're battled over the money. Again, I thank you for the opportunity to speak to you today. If this bill does not pass, we can't give up. You got to keep fighting. We have to keep continuing to tweak the language in a way that's more palatable. I think this is a very aggressive bill. I think that my only concern about it not being passed is not that it's right, it's that it may be too aggressive. That's my fear. And I don't mean too aggressive in the sense that it's not aggressive in the right way. What I mean is it's such a fundamental shift that this law will implement, but it'll be a fundamental shift in the right direction. And I hope that there's any lawmakers that are hearing my words that they'll not be afraid of what kind of a fundamental shift that this law will cause. The fundamental shift will be beneficial to families. It'll cause long-term stability between relationships that actually in some ways might have a chance to continue. I've seen cases where husband and wife just had a difference of opinion in how their relationship was going. They go into divorce court and they emerge as the worst enemies. And that doesn't have to happen. Some of these relationships, when the divorce started, were not deteriorated to the degree that they were when the judge rendered his ruling. And I think the current state of the law encourages that discord. It encourages all these battles to be waged that are unnecessary. Again, thank you for your time. Try to get the word out and encourage your legislators to support this bill. And thank you.
Thank you, Justin. There's some powerful words from someone in the family law industry that stands a lot to lose should this bill pass. So we appreciate his honesty and coming out here. Thank you.